Okay, we have a short agenda. We only have two bills that we're voting on, so unfortunately I'm going to go a little out of sequence. I'm going to start with A2799. Adrian, if you could read it. This is for discussion only.
A2799. This bill provides the disclosure by the custodian of a government record or of the primary or secondary home address of an elected official or a person seeking elected public office or their immediate family member, except in certain circumstances. The disclosure would be prohibited if the elected official or person seeking elective office or the immediate family member submits a request for redaction or non-disclosure to the Office of Information Privacy in the Department of Community Affairs.
Thank you. So, John P. Schmidt, both as an individual and as New Jersey Foundation of Open Government. He'd like to testify, and he's opposed. Can you push the button? No. That's it. It's on.
Okay. Mr. Chairman, members of the committee, thank you for allowing me the opportunity to make some comments regarding this bill. First, I would like to talk this from an individual, more as an individual. I am a registered municipal clerk and have served as a municipal clerk. And in reading the bill, I do have a few concerns how it would, I think, impact the municipal clerk as primarily as their role as the chief elections officer in the municipality. Under Title 19, which is election law, it allows for members of the public to make election challenges to petitions. And those challenges are filed in the first instance with the municipal clerk as the local elections officer for each of the municipalities. I have been on the receiving end as a municipal clerk probably of over a dozen election challenges, including multiple challenges challenging an individual candidate's residency requirement. The way this bill is written, it would seem that the address of the candidate would have to be redacted. So if I'm a member of the public and want to review the petitions immediately after they are filed from my local municipal clerk's office, I could review them, but I would not be eligible to obtain the address listed by that candidate. Knowing that address as someone who wants to go through a petition, I would be then able to make a determination of whether I want to file a challenge of whether that individual meets the one-year residency requirement to run for public office. And I'm concerned that this bill would essentially gut what the public's right under Title 19, nor does it make any provision for releasing an elected official or candidate's address on the election petition if it's for the purposes of reviewing it to ascertain whether a member of the public wants to make a challenge. My other concern regarding the bill from an individual standpoint is how it would redact candidates' home address. But it seems like only while they are running for office. There are a lot of people who might run every year in a primary or a general and never get elected, but that's their right to run. So you would have a period or portion of the year where somebody's address would have to be redacted, and then once they would assumingly lose, they would no longer be a candidate, nor would they be elected official, so all their stuff would be then unredacted. It would be like an on-off switch. And I feel like that's a little, would be insanity for records custodians. To speak in an official capacity as Vice President of the New Jersey Foundation for Open Government, changing hats for a second, NJ Fogg opposes this bill. Our government is by the people and for the people. Being in elective office is optional. It is not a primary career or a day job. What the amendment would do is essentially create a separate class and separate rules, one for elected officials and one for the public for whom they serve. It takes away, as written, individuals' rights under Title 19. It creates redactions only for a certain time period for a select few people. And finally, the current Office of Information Privacy in DCA has been somewhat of a disaster in implementing Daniels Law. Since the implementation of Daniels Law, the FDS forms, going back to 2015, found on DCA's website, have been completely wiped clean and redacted. Whether individuals are protected under Daniels Law or not, all information has been redacted by DCA because they can't figure out how to, well, who's protected and who's not. So let's redact everyone's. And it's denying the public access to information that they should have access to. So I thank you for listening to me both as an individual and for the, as a board of directors for the NJFOG. Mr. Chairman, members of the committee, thank you for your time.
Well, for my own opinion, some of the stuff in the bill, which when I read it, I feel there's a little difference of opinion. The clerk, who is the holder of every single candidate, appointed or elected, all the way down to a committee member in a local town, will have that address. So if there is a challenge, the clerk will be able to make that determination without having to give that information out to the general public. With speaking with the prime sponsor regarding his bill at this time, it's been discussed, and that's what this is about. It's about discussion. It's not. We're trying to make this right across the board. The other part of this is how do I say this? Most of the people sitting here today at this dais, this isn't going to help them, because everything that I've done in my years being on council or appointed or now sitting here as a state assemblyman, all of our information is out there for the public. And it's been out there for many, many years, not a couple months. This will help people in the future. Do I believe that the public has every right to come and talk to me anywhere they want, whether I'm in a deli or whether I'm here? Absolutely. However, do they have a right to come to my house? And not every time they would come to there would be a, let me shake your hand and you did a great job. Typically that doesn't happen. It's the opposite. And to put any one of our family members in a situation like that, where they're not the elected person, I don't feel comfortable. We've seen it nationwide where there's been things that have happened that I believe shouldn't happen, period. So I believe that this, in my opinion, again, that the safety of our families is paramount over above the public's knowledge to know where you live. Again, that's me. But you could come talk to me anytime, anywhere. You could have my cell phone by getting it through the legislative office. You could ask me for it and I'll give it to you right now. It's fine by me. Call me anytime. And I'm sure every single person up here would do the same thing. We're here for you. Us. We're here for you. Not my wife, not my kids, not my in-laws, not them. Me. So I respect your opinion. I'm just telling you what I believe, the way I read the bill, but I'll be happy to talk to the prime sponsor about it, and I'm sure he'll want to look at this, and we'll get to more of the details and make sure that this doesn't hurt anybody in any way for the public, but also has to be for us too. That's what this bill's about. Thank you very much. If anybody else has any comments, please. No? Okay. Then Andrew LaFerrick, New Jersey League of Municipalities, in favor, no need to testify. Thank you. Anybody else? Then with that, I'm going to close the bill. Thank you for your opinions and discussions. We do have a letter from the League of Municipalities, which everybody should have. Thank you. Then we'll go right to the next bill,